But it's also, in my submission, again, not about jurisdiction. It's difficult to see how any of what we're talking about is about jurisdiction. It's about the approach the court should take to something that's clearly within jurisdiction because of Section 26. It's about procedure. Turning then to Section 26, my learned friend says Section 26 is only concerned essentially with the ECHR. I recognise that the ECHR is a flaw, but I would not accept it as a ceiling when interpreting the Bill of Rights. If one looks at Section 1 of the Bill of Rights, which neither of us have taken you to, but it's important, it recognises essentially the distinct values of Cayman society. And in our submission, the common law is a key part of that. It would be somewhat surprising, to put it mildly, if the Bill of Rights didn't safeguard basic common law standards. Given obviously the importance within Cayman society of common law principles, or indeed any common law jurisdiction, common law fundamental rights, and Cayman's not unique in relation to that. And then my learned friend says Carnduff is a determination. I'm sure you're going to go away and look at Carnduff. I took you to the passage which shows it's about access to the court. And this is a critical difference. Strasbourg in our submission recognises in Article 6, C Carnduff, that states can restrict access to the court. It is not inconsistent with Article 6, providing it's proportionate. You're not then getting a determination. If you don't have access to a court, you're not getting a determination of the case. You're getting told effectively this is something that the court should finally determine. It's the contrary, is the exact opposite of determination. Here, and this is why Section 26 is expressed so important, and it reflects in our submission, that's why I took you to Polyakova, for example, about the importance of there being a determination of human rights claims. Here, because Section 26 applies, it requires a determination. And that must be a determination on the merits. It's not a determination otherwise. And that's the critical difference in our submission between Article 6, Section 7 in this context, and Section 26. Finally, my learned friend turned to his sort of alternative argument that Section 26 essentially authorises a CMP, but that's premised on the basis that a conventional PII exercise isn't authorised or is in some way unfair. And of course, we come back to the fact that there is plenty of authority, and I just took you to Arawi, that a PII exercise is fair as a matter of common law. Well, I think that covers everything I need to cover, unless there's any further questions.
Thank you very much, Mr. Southey. Well, we've had a vigorous discussion. You've given us a number of important issues to think about. We'll now consider the submissions on both sides, and in due course we'll tender our advice to His Majesty. Court will adjourn.